Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip has to do with the closing attorney as the holder of the earnest money when the buyer and seller are binding on the GAR, the Georgia Association of REALTORS contract forms. So I'm going to start with the punchline. The punchline is when a buyer and a seller are going to negotiate to have a closing attorney as the holder of the earnest money, you as agents, there are two forms that need to be signed. One is an exhibit to the contract, and the other is an agreement by the closing attorney to be the holder. So what I'm finding in contracts is agents, you guys are including both of those documents, but you're not getting the appropriate signatures. So bottom line is buyer and seller sign the exhibit, but the closing attorney is the one who needs to sign the agreement, and that is missing, and therefore a lot of your contracts are out of compliance, and what you're doing is you are throwing the buyer in default of the contract. So let's go over it a little bit more in depth. When a buyer and chooser in the GAR contract forms choose to have a closing attorney as the holder of the earnest money, you must include Georgia Association of REALTORS GAR Form F10, which is an exhibit, and it says it on there. It says closing attorney acting as holder of the earnest money. You fill it in with the offer date. You write out the contact information of the closing attorney whom the parties are going to choose to hold the earnest money. And very important, number 7, you must fill in the alternate holder if the closing attorney chooses to not be the holder of the earnest money. If you leave that blank, by default, it becomes the buyer's broker. And then the buyer and seller initial this. Now, once you go under contract, the burden is now on the buyer. The buyer has 3 business days. The buyer has 2 business days from the binding agreement date to get an agreement to the closing attorney to sign and a copy of the entire contract. So this is the other form that does not need to be part of the contract. It is a standalone agreement between the closing attorney or by the closing attorney to act as holder. This is the GAR Form F511. And this one says agreement of closing attorney to serve as holder of the earnest money. And it spells out all the duties and responsibilities that the closing attorney agrees to fulfill. You have the contact information for the buyer and the seller. And then the signature line on this is the signature of the closing attorney or the representative. This has nothing to do with the buyer and the seller. They don't sign this. This is not part of the contract. It is a standalone agreement. However, the closing attorney must get a copy of the contract and sign this agreement within 3 business days in order to say that they are agreeing to fulfill their responsibilities. If not, then the alternate holder automatically becomes the holder of the earnest money. So again, what we are seeing on a lot of contracts is, number 1, agents are including both of these forms in the actual contract. The second form, the agreement, is not part of the contract because it's not signed by the buyer and the seller. The second mistake we're seeing is we are not getting closing attorneys signing that form agreeing to be the holder. You guys, there are a lot of closing attorneys that won't agree to be the holder. The amount of earnest money might be too little. The amount of earnest money might be too large. They may not sign it and agree to it until they actually receive the earnest money. They may not want to fulfill all the responsibilities that's outlined in the purchase and sale agreement of the holder. They may have an ongoing client relationship with one of the parties in the purchase and sale agreement. So there are a lot of reasons that a closing attorney you may not have asked them, the buyer may not have asked them to sign that agreement. There are a number of reasons that a closing attorney may simply not agree to hold the earnest money. If that's the case, then the alternate holder becomes the earnest money. But then the confusion comes in where you've told your buyer to send the earnest money to the closing attorney. They're not the holder. So the alternate holder now sends notice that the buyer's in default because the alternate holder is now the holder of the earnest money and never got it. So agents, you need to be extremely careful and pay attention to the documents you're using and what needs to be signed by whom, within what time frames, and what that all means. Nothing's an issue till it's an issue. But if there is a termination and both parties don't agree to the disbursement of the earnest money, that is one of the many jobs of the holder of the earnest money. Additionally, if the buyer never turns in the earnest money, that's a job of the holder to send notice that they didn't get it because the seller has termination rights. So there's a lot going on here. Additionally, y'all need to pay attention if it is an all-cash transaction and the closing attorney is the holder of the earnest money, it fails to close and there's a dispute. Buyer and seller don't agree on who gets it. We don't get signatures on the release portion. The closing attorney is required by the contract to interplead the money into a court and let the judge decide. And all of the court costs and all of the legal fees come out of the earnest money before it is dispersed. And it's a lawsuit involving the buyer and the seller in a lawsuit over those funds. So, bottom line. Please have a discussion with the buyer and the seller about the brokers holding the earnest money. If for whatever reason they choose to have the closing attorney as the holder of the earnest money, you guys as agents, y'all need to really have had a pre-conversation with the closing attorney. Are they willing to hold it? Are they comfortable holding it? Are they willing to fulfill all the responsibilities, so forth and so on? If that's the case, then, got my Halloween ringtone. Isn't that fun? All right. I'll get that in a minute. If the closing attorney does agree, the burden is on the buyer per the contract to get the full contract and the agreement to the closing attorney within 2 days of binding contract, and then the closing attorney has 3 business days to sign it. Make sure you get those signatures, especially the closing attorney signatures, and read through those agreements and make sure that the buyer and the seller understand what all of that means, and make sure you have a discussion with the closing attorney what all that means and if they are willing to be the holder or not. Thank you guys so much for watching. Well, let me back up. Without the closing attorney agreeing to it, that's like you're having your buyers give the closing attorney thousands and thousands of dollars with nothing in writing. Closing attorneys could do anything they want with it. Now, they can't steal it. Don't get me wrong. They can't steal it and use it for their own purposes, but they are not bound by any terms of the contract. If they are not bound, they don't have to give notice to the parties if they don't receive it, if they don't deposit it. If the contract terminates and the buyer and the seller don't agree on what happens to the earnest money, the closing attorney can give it back to whatever party they want. If you have a fully executed T&R, but the closing attorney has never signed anything agreeing to be the holder or fulfill those responsibilities, closing attorney can give it back to whomever they want. Closing attorney can give it back to the buyer even if the buyer defaulted, if the closing attorney has not signed that document, that agreement, GAR F511, agreeing to fulfill the responsibilities of the holder as outlined in the contract. You guys are just, they don't sign for that. The closing attorney is not a party to the purchase and sale agreement. They don't sign that at all. So even if a buyer and a seller say, remember the old Life cereal commercial? Hey, let's get Mikey. He'll try it. He'll try anything. Well, if the closing attorney doesn't agree, they don't sign to it. You can't agree to have a third party take on all of these responsibilities without them signing for it and agreeing themselves. Another thing, if the parties are not binding on a GAR, Georgia Association of Realtors contracts, and you guys are putting the closing attorney as the holder of the earnest money, same thing applies. There's nothing in writing by the closing attorney for them agreeing to fulfill any responsibilities as outlined in the contract regarding what they do with those funds. And all of that is how you explain to your buyer that their earnest money is protected or at risk. In the RE Forms contract package, there is an escrow agreement. So if the buyer and seller are binding on the RE Forms contract package and you want to have they choose to have the closing attorney as the holder of the earnest money, they would use RE Form 215, which is an escrow agreement. While we're on this topic, there is a GAR escrow agreement also, and that is RE 513 escrow agreement. So this is also something to keep in mind if your buyers and sellers go binding on another contract other than the GAR contract packages or the RE Forms contract package. If it's a HUD contract package, Fannie Mae, Freddie Mac, investor, attorney written, you need to read through the holder of the earnest money and all the responsibilities that party takes on. And if it is somebody other than the seller's broker or the buyer's broker, you need to get their signature agreeing to fulfill those responsibilities in order to protect the earnest money, or make sure that what you are informing the buyer regarding the disposition of their earnest money should a contract fail to close, and informing the seller about notification if the buyer never turns it in. You guys need to read through all that stuff and make sure the parties understand it. Thank you guys so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.